A very good afternoon to everyone joining us today. On behalf of Eastern Book Company and SEC Online, it is my honor and privilege to welcome you to this special interview session. Today, we're deeply honored to be in conversation with Professor G.S. Bajpai, the Vice-Chancellor of National Law University, Delhi, and a distinguished scholar whose work in criminal law, criminology, and victimology has contributed significantly to contemporary legal discourse. Over the course of his extensive academic and administrative career, Professor Bajpai has authored 22 books, more than 60 research papers, and several influential project reports, including recent works such as the Handbook of Laws, the Case Laws for Victims for Crime, and Hate Crime in India. His scholarship includes pioneering conceptual contributions in areas such as victim justice, victim jurisprudence, wrongful prosecution, and critical criminal law. And his research has informed major policy deliberations in India. Professor Bajpai has also contributed to law reform through various national level engagements, underscoring his long standing commitment to strengthening India's criminal justice system. Sir, it's a privilege to have you with us, and we are grateful for the opportunity to engage with your insights on legal education, criminal justice, and research. I would also like to introduce our interviewer for today. Harshvardhan Yadav is a student of ILS Law College Pune and is also the EBC SEC online ambassador for the year 2025 to 2026. He has keen interest in legal research, writing, and publication, and he will be conducting today's interview.
Good afternoon, sir. It's an honor and privilege to have this conversation with you on behalf of Eastern Book Company and SSC Online. It's been 4 decades of your extensive research and reform that have transformed India's criminal justice landscape. Your work has redefined the manner in which our legal system perceives victims, wrongful prosecution, and justice delivery. Concepts like victim justice, critical criminal law, and wrongful prosecution are now integral part of the Indian jurisprudence because of your vision. So, if you could please share your journey with us, what were those pivotal moments that shaped your career trajectory in criminal law, criminology, and victimology?
First of all, I convey my sincere thanks to EBC, SSC, and of course, both of you for having me today here for this conversation. And to respond to your question, the important thing in my formative years was my exposure to the very important Department of Criminology and Forensic Science, which was situated in Sagar University in Madhya Pradesh, where I have studied my initial years. And there I came to know about the existence of this exclusive subject called criminology. It actually inspired me, and I enrolled to my graduation studies in this particular field. And I realized that this is a very unique subject because, as you may be knowing, this subject at degree or post-degree level is not at all existing in many places, even now. But around those days, this was quite exciting for me personally because I wanted to understand the criminal justice system from the lenses of criminology. And when I joined this graduation program, I realized that this subject has huge potential to understand the world of criminals, criminality, juvenile delinquency, correctional administration, forensic psychology, and all these things have further prompted me. So I did my master's also in that subject before I moved to Delhi and other places. And I also say that the initial years were very, very important and significant for shaping my interest in this area. And I started visualizing a situation where we can make a criminological or a victimological reading of criminal laws and criminal justice, because that understanding is something which contemporary criminal law scholars have never looked at. Because criminal law scholarship was mainly confined from a single discipline orientation. but I wanted to understand criminal law from the lenses of behavioral sciences, from social sciences. And therefore, in throughout my journey in all these 4 decades, I have been making efforts to read criminal laws, say from the lenses of victimology, from the lenses of criminology, which provided me a very unique orientation and a unique situation. And my all writings and research has then inspired me to take further studies with the help of a lot of people, even to the extent that I decided to go to the uh, UK for my postdoc, which I did in Leicester University and Cambridge. There also I studied situational crime prevention, criminology, and victimology. It again provided me a lot of impetus and a lot of orientation to my thinking. And as a result, I have undertaken some empirical studies, interfacing criminal law scholarship, criminal justice studies, and then I produce a lot of writings, and significantly enough, those have become quite, noted and cited very often. And then this entire journey started, and it's still continuing, and I keep writing in all these areas.
That's really fascinating, sir. My next question is, how has policy in India changed since your early work at Bureau of Police Research and Development? And what critical gaps remain in police training, accountability, and victim protection?
Actually, again, this was very early in my professional career when I joined Bureau of Police Research and Development. And again, I was very curious to understand the law enforcement agencies, how do they deal with the crime. In terms of research, I had the occasion to study, police behavior, police projects, and all that. And I still very distinctly remember 2 studies which I have done around that time, I mean, several years ago. One was on community policing, which was very new to India, and I did a countrywide study. And again, I was able to secure some unique insights about the experiment of community policing in India. Second, I did a very unique study for the BPRND again, that was on victims of violent crime. And I was trying to understand how the police was responding to all these victims, witnesses, and all that. Because to me, the police is a very conventional and orthodox organization, and the extent to which the knowledge from the disciplines like criminology and victimology was able to influence the police behavior, policing systems, and all that. So around those time, I believe that the modernization in police was simply developing, and the debates were around the community policing, the I would say citizen-centric policing, problem-oriented policing, and all these new ideas in police were emerging. And in many states, some experiments were also being undertaken, and I was fortunate enough to see some of those things in the making. So I would say that police continues to be a very, conservative organization, if I say so. But in many places, I could see, because of the initiatives of various individual police officers, certain experiments were being undertaken. And I believe that if I put all these things together, the police was significantly impacted by these developments, because researchers were doing research. They were saying around that time, you may be knowing the issue of custodial violence, human rights issues, high handedness of police, custodial torture, custodial deaths, custodial rape, even. These things were actually critically auditing the work of policing, making them accountable. And this accountability question was actually in the making. People were demanding the accountability from police, and therefore, police was forced to create a very transparent and a very vibrant and dynamic system of accountability so as to secure the confidence of people. So all these debates had profound impact on policing, and I was fortunate, as I have said, to be the part of some of these developments. So that was the story.
Thank you, sir. Building upon the same question, how have your different positions from BP R&D to NLU Delhi shaped the understanding of criminal justice reforms?
I would again say that I was very fortunate that I had the opportunity to work with VPRND, because that was a kind of think tank to the Ministry of Home Affairs. It continues to be a think tank. And the experience which I gained there, and when I moved to the National Law Universities, before NLU Delhi, I worked at National Law University at Bhopal, NLIU. And while I was working there, I brought with me a lot of experience in working in the Indian Police, the Bureau of Police Research and Development. And when I joined again, I continued with my interest in these institutions. And when I moved to NLU Delhi, as you mentioned, in NLU Delhi, being located in the capital, I had again a very unique sort of situation where I was interacting with ministries. I was trying to say that the criminal justice research can be looked at in a very new way. And around that time, I was trying to emphasize on two things. One was, since I was a very trained researcher, as I have said, I have done a number of field-based research projects on the issue of victims, criminals, prisons, and all that. So I had a lot of rich experience of doing empirical research. So when I joined National Law University, Delhi, I realized that the law researchers and law academicians were not that proficient, say in, for instance, planning in empirical legal research or data collection techniques or data analysis techniques. So I started organizing number of workshops for training the researchers in terms of empirical legal research, data analysis, report writing, and kind of thing. And I was able to pinpoint one significant thing to all my colleagues and a lot of people who work with me. That was the fact that knowing law in terms of number is a very important thing, because the classroom, because when I was teaching to UG student and when I was having conversations with my colleagues, I was trying to raise this question that whatever you are saying based on the black letter law. There is no opportunity to actually examine those things with the help of quantitative data or quantitative technique. So you don't have any empirical understanding of criminal law. And around that time, I have used a phrase which is still very nascent, I would say. I said we should try to explore what I call empirical criminal law. Empirical criminal law would mean, suppose I teach arrest law. Arrest law will be taught to a student with the help of either text of the law or through the case law. But I was saying, let us see how the operation of arrest law takes place in a police station. Let us observe. Observing means you are then empirically able to grasp and understand. So this was a unique thing. And then I started doing a small research in various aspects of substantive criminal law, procedural law. And I was saying that let us do some empirical. We should test some presumptions, strong presumptions in criminal law. So I brought a lot of research-based understanding to the criminal law that I considered to be my little contribution to this field. And thankfully, NLU Delhi responded so positively that we were able to create a lot of infrastructure and a very robust ecosystem in which we have then conducted a number of studies. You may be knowing about so many centers and so many cells which have produced some very cutting edge research, which even attracted the attention of the courts and the ministries. And they have approached us number of times to request that, look, we have to make a study on these things, because evidence-based policing, evidence-based criminal law, data-centric decisions making in criminal justice planning, and all those things which we regularly study, like bail, arrest, conviction, sentencing in criminal law. All these things we know only abstract manner. But knowing these things in terms of number, data, quantity is a unique thing. Still, it is very, very, I would say, rare for most of the law schools, if I can say so.
Thank you, sir. Your insights on this particular issue are really valuable. Moving on to the next question. What inspired you to develop concepts such as victim justice and wrongful prosecution, and why do they matter for India's criminal justice system?
So I think this happened all in the process, actually. So as I have said, that we were working very passionately uh, in terms of victim and victimology. And around that time, I have also set up a center in the National Law University, Delhi, which is called Center for Criminology and Victimology, which has done some very good research work. So I realized that the criminal justice was a very dominant theme of criminal law scholarship. And criminal justice indicates the reliance and focus on the accused, the criminal. And in fact, justice system in India works in a manner where the accused or the criminal is in the center, and all the services work around him or her in terms of legal rights, entitlement, support system, etc. I was trying to explore, is there any system which I may call victim justice? So this is the reversal of criminal justice. And I started using this terminology, victim justice, which was never there in books. If you consult the books, it was never there. So I have instituted this word when I wrote a book on victim justice, which was published by Thomson Reuters. And this book has introduced the idea of victim justice. So all it says is that we need to deploy a perspective to the victims of crime. And let us start focusing on the system of legal justice or criminal justice from the lenses of victim. So that, because victim is also a party, and rule of law and fairness of the procedure say that justice has to be equal to both the parties. If it is equality before law, you cannot ignore the victim. So plight of the victim was addressed when I started highlighting and emphasizing victim justice. And this is not simply a term. It actually says a lot about the deployment of rights, entitlements, protection, privileges, support system, and everything to the victims of crime as they are generally provided to the accused or the criminal. So the victim justice emerged like that. As far as the other aspects which you have mentioned, that is the wrongful prosecution. Actually, if you examine the literature, in the US, there is a term which is very prevalent, that is called wrongful conviction. So they have a system, even after the decision of the apex court, the case can be opened by a particular committee if it recommends that, then the Supreme Court or the apex court in different states will hear those matters again. So I thought that in India, since we do not have any system which can, be similar to wrongful conviction. However, I realize in a number of cases where the accused who are tried by trial court, and then they are sentenced. And again, they prefer appeal, but after 2, 3 years, they are released. The period that they live after the appeal, that, and if they are again acquitted, then 3, 4 years, 5 years, it is actually the wrongful prosecution, and I would say it's a wrongful conviction also. I think a couple of days ago, I have written an article in the Hindu on Nithari killings. In Nithari killings, we all know 13 children were killed and 2 accused were tried for 11 to 13 years. They were in the prison, and later on they were acquitted. I raised this question. This acquittal is of no consequence. They have already served prison for 11 and 13 years. And you are now saying they are acquitted. So this acquittal is actually very, very traumatic. And the fact remains, there is no remedy. There is no compensation in the law for such kind of people. So I have actually started studying this aspect, and I have guided many dissertation, and I have done a book also later on this subject. So this all started like that.
Thank you, sir. That was a really illuminating explanation. Building upon the same question, in the Bablu Chauhan versus State case, you introduced the idea of victim impact reports. How can this framework be adopted across courts to strengthen victim-centric justice?
So basically, I was appointed as amicus by the Delhi High Court in Bablu Chauhan case. It was again a case of basically wrongful prosecution, because he was a fruit vendor and he was charged for murder, and he was sentenced, I think, for life. And while serving the life sentence, he preferred an appeal and he was acquitted. And the Delhi High Court wanted me to examine that what can be done to this situation to mitigate this situation, because there is no provision of providing any relief to Bablu Chauhan. He served for some years as wrongfully prosecuted person. So I wish to tell you that my report has resulted in the direction that the High Court made to the Law Commission to study this aspect and make suggestions. And in turn, report number 277 of the Law Commission was focused on this subject, and they have suggested some scheme. I may be having some different views on that report, but fact remains that they contributed to this particular field. That report has not been implemented, that is another matter. But for the first time in the country, through a court, my report and my terminology of wrongful prosecution was actually accepted and institutionalized and became a kind of discussion point by many. And amongst other things in that report, I brought the idea of wrongful prosecution as well as victim impact statement. But to tell you some more facts about it, there was another case of Sunil Tyagi versus the state of NCT, in which also the similar situation happened. And the need, I was again serving as amicus in that case also, and the need for developing what you call victim impact statement was, made the part of my report. I developed that because I have worked uh, in Hague for some time, where I have studied this idea that there can be a system of victim impact statement in the courts, on the basis of which two things can be easily calculated and understood. One is the quantum of compensation that may be given to the victim, and second, the quantum of punishment that can be awarded to the accused person. But victim impact statement is basically a very unique system through which you can capture the actual extent of harm suffered by the victim. Why I'm saying so is the fact that simple illustration or description of a section, say if I say the person was grievously injured, that may not make a sense the extent of suffering and harm experienced by the victim, because for me that suffering may result into some different kinds of consequences, but you may be having a different set of consequences. So the provisions of criminal law are very similar in all kinds of violence. However, they impact very differently to all people. And that was the thing that I wanted to actually bring to the notice of the decision makers, to be able to decide various, process in the course of a trial. So victim impact statement is very popular in the US, in Australia, in many other places. So that was another small effort which we tried to introduce in our legal system. However, it is still a long way to go, I would say, before we see the full-fledged introduction of this particular measure.
Thank you, sir. That really clarifies my doubt. My next question is, as convener of the Criminal Reforms Committee, how do you view the Bharatiya Nyaya Samhita, the Bharatiya Suraksha Sanhita, and the Bharatiya Sakshi Adhiniyam as a paradigm shift from the IPC and CRPC? And what were the most challenging issues your committee had to address?
In fact, it's a very big question, because the task that the National Law University was assigned in terms of producing a report on the reforms, which recommendation of these reforms to the three criminal laws of the country, and a team of researchers, maybe 30, 40 people worked with me. That was the COVID period, and there were already a lot of challenges before us. But the main point was, when the question of reform was undertaken, there were a lot of discussion in the ministry and with many people. And I was of the confirmed view, because of my long, years of making assessment about criminal law and criminal justice. I was of the view that it should be a principled criminal law reform. Principled criminal law reform will mean that what are the principles on which the criminal law reform should be based. So we have formulated as many as 11 principles, and those principles are informed by the choices which the modern criminal law jurists maintain, the new philosophy of criminal law advocate, and number of new researchers and researches convey as to what kind of minimalist and what kind of efficient criminal law system the India should have. Based on that, we wanted not simply a penal code, we wanted a justice code. Because punishing the people is not really the objective of criminal law. People generally think criminal law is meant to punish people. But criminal law is meant to provide justice to the people. So justice orientation was the first paradigm shift in the very conceptualization of the various sections of substantive criminal law as well as procedural criminal law. Second, we also wanted a very constitutional orientation to the criminal law. These criminal laws were evolved when Constitution was not in operation. Now we have the Constitution of India, which is the test of assessing the suitability of legislations. So we tested the requirement on the touchstone of Constitution. That was another dimension. Third was that continuous legal aid and a very robust accountability system to be integrated in the new criminal law, which was done in terms of, say, for instance, laying down the timelines and all those things, and making the police and law enforcement agencies more accountable. To tell you some innovations which we conceptualize, I can quickly recall that I was researching some time ago on trial in absentia. And I put forth this idea that let us have trial in absentia, because in Sunil Tyagi, when we were working, I realized there are 100,000 of people in India who are absconding, who are evading trials and investigation. They are not trustable. So the cases in such cases are generally closed. But I was trying to convey that if somebody is willfully evading the criminal process, let there be trial in absentia with due safeguards and all kinds of protection, which may be admissible. So those things have also been introduced. And also, if you see the rearrangement of sections and the introduction of the chapter on crime against women, and in procedural law, if you see the legal aid provisions and all those things are too many. I must say that in our original reports, there were a lot of other things which we wanted to include, like sentencing, victim protection, victim justice, legal aid. Those could not be done for various reasons, but still these criminal laws have redefined the manner in which now the criminal justice system should function in terms of efficiency, speed, and also by utilizing technology. We introduced a lot of provisions which insist for the application of technology. So these were a lot of important things. As far as making of these criminal laws are concerned, I must confess there are a lot of things which were there in the uh, whole process of making, because as I have said, it was the COVID period and a lot of experience of interacting people. Some of them have been accepted, some of them have not been accepted. And I'm planning to document at some point of time the story of making of criminal laws in India, and probably that will answer a lot of things people want to know in general.
Thank you, sir. That insight will be extremely valuable for our audience. My next question is, having served as the Secretary General of World Society of Victimology, how does India's approach to victimology compare with global best practices? And what international lessons can we adopt while staying true to our constitutional values?
So I am the part of the World Society of Victimology for last several years. When I was elected as Secretary General and I have completed my term, it's a elected position. And in our last conference in Spain, I was elected for this position. And the idea is that the countries at large must amend the laws and their procedures to suit to the requirement of victim justice in general. There is a instrument called UN Declaration on the Victims of Crime and Abuse of Power, 1985. That document is largely a very important guidance to the contemporary criminal justice systems to amend the laws and procedure and the institutions to provide victim justice efficiently and effectively. As far as India is concerned, uh, I would say that at the level of the state, the beginning has been very slow. But on the part of court, the dynamism has always been very, very noteworthy. If I say a lot of victim jurisprudence in this country has emerged because of some path-breaking judgments from the Supreme Court of India and, of course, some high courts also. And that case law, I have also compiled these cases in my book, and I was able to install what you call another new terminology, victim jurisprudence. or victimological jurisprudence, which is still not taught in classes, but people should understand that the Supreme Court and many high courts have been saying this, that there should be clear-cut grants of certain pre-trial, post-trial rights to the victims of crime. And very significantly, they have in many cases also laid down that the victim should achieve a party status in trial. The victim should be made to participate in the trial, which is not happening in most cases. So this is a very recent beginning. So unlike other countries where the victim activism and victim justice came through institutional and legal changes, in India, it has come because of the court's dynamism. And that has brought a very new kind of victimological activism, which has happened because of some very path-breaking rulings of the Supreme Court, which are binding definitely. But recently we have seen some changes in various local and special laws, which are definitely placing the victim in a better position. So I believe, though the India and the global terms is still, I think, lagging behind, but I would not say that picture is completely dismal, because we are making significant strides now in this direction.
Thank you, sir. That really adds a great depth to our understanding in this subject matter. Moving forward, the next question is, under your leadership, extensive digital resources were developed through the EPG Pathshala project. How is the transformation of legal education by technology understood, and how can digital platforms be leveraged to improve access nationwide?
So around 2016, the University Grants Commission launched a scheme called EPG Pathshala and MOOCs courses. And they wanted the law schools to develop, the modules, the e-text as well as video modules in very simple language for the uses of various law students across the country. Because the legal education is not universally distributed in terms of class and quality across the country. Some colleges are better located, better privileged, not others. So with this idea in mind, the UGC wanted, and they have floated this idea. Again, NLU Delhi came forward, and we have undertaken a very, ambitious task of creating modules, EPG Pathshala modules uh, for various subjects in undergraduation. So I remember for 16 modules, we have covered almost 30, 40 papers, and some 400 e-text and 400 videos we have produced. And that e-resource is by far the biggest e-resource which is available in the country. Anyone can see this is freely available. And this was utilized by a lot of people. And again, for that task, a very big team of more than 200 people worked with me. And we have created these digital databases for the subject of law and criminology, as I have said, in more than 400 modules. And that was again a very unique experience, because nowadays the digital technology is so easily accessible and available, but 2016 it was not so prevalent. So that was again a very satisfying experience as far as legal education growth is concerned.
Yes, sir, that was a really dynamic change indeed. My next question, building upon the same, is India's criminal justice system faces challenges like case backlogs, delays, and witness intimidation. As Vice Chancellor, what institutional reforms are you introducing at NLU Delhi to prepare students to tackle these issues?
See, these are the policy issues. If you talk about case law as backlog, or if you talk about pendency, or if you talk about the witness intimidation, or if you talk about any other process, we as a university has a duty to highlight not only the issues, but also the solutions. You will rarely find people showing a small experiment which can be done to decongest the court, to accelerate the trial process, to accelerate the case processing, to sort of provide some kind of solutions to a lot of problems. And that is what I have been saying, that in this university, we have undertaken some projects through which we were trying to say that we are not saying that this is the problem. We are saying this is the solution. NLU Delhi's death penalty project, Project 39A project, we have undertaken a massive work of providing legal aid to the under trial prisoner. Thousands of prisoners in Maharashtra have been released because we trained the lawyers to take up their cases. If we say that under trial thing is bad and it should be resolved, who will resolve it? Why can't you organize something which can make some difference? So we have recruited the lawyers, we have trained them, we have given their cases to them, they have gone to the court, they have taken up their cases, and they were able to release them on bail. I'm telling you, this is the solution-oriented. We have intervened in cases of death penalty in number of cases. So pro bono lawyers we have organized. We requested them to take up their cases and go to the, and you have those reports in public domain available. You can see in how many cases we were able to get the death penalty converted into life imprisonment. And many people were acquitted also in many cases. So these are these forward-looking solutions which we can provide to the criminal justice system through legal education experiment, through legal aid experiments. So what I'm saying, the legal aid should become functional. Very recently, if you are aware, I have undertaken a first of its kind in the country project, similar to Project 39A. It is called Victim Advocacy Project. And this victim advocacy project, Azim Premji Foundation is supporting us. We would be actually going to the victims to provide them legal aid, to provide them guidance, to provide them intervention. And there would be a team who would be trained and deployed to deal with this. This is the pragmatic, solutions to the problems which are discussed in the classroom. Alone, National Law University really cannot do it alone. A lot of law schools will have to, train the students to do such things. So these are very important experiments.
Thank you, sir. That was a really powerful observation. And I really hope that all the law schools implement such institutional reforms at their own institutions.
And mostly, I'll interrupt you to say one more thing. The students were the main drivers in all these projects. They are still the part of many experiments that we do. And the students' participation with their vigor and their enthusiasm, they take up. And I was just, having conversation with a student who was motivated in my conversation to take up the cases in which where the government has a provision to provide, those food and other services, grain and all those things as a part of government schemes. But most of the urban poor are not able to take advantage of those schemes because they don't have document. So this student who is studying here in third year, he got motivated in Rajasthan. He contacted, he was only getting those documents arranged for these people. And he was able to provide some, 200 people this service. And as a result, they were able to access that grain, food and everything which government provide. And this experiment, he converted into paper which the Oxford Law Journal is publishing. This is a small story, but these things are very inspirational.
Yes, sir, it has really enriched our discussion. My next question is on, as a leading academic and researcher, how do you view the role of SSC Online in supporting contemporary legal research, and how has the access to comprehensive case law databases shaped your research and policy work?
I have always been a great admirer of EBC, SCC, for various reasons. Number one, these days, the need for a systematic access to the case law data and articles, various kinds of compilation, publication, all these things is a very important requirement because the law students do immense research, their projects and all that. And all they need is a very, smooth platform. The thing that I appreciate for SCC, the platform is very, very convenient and very, very informative at the same time. And the accessibility to the data, to the cases, to the articles, everything is so simply available on one click. And over the years, I have seen that SCC platform has added several new features in keeping with the digital requirement in mind. You have app, you have platform. So all these things always attract the attention of active students and active researchers. I have no doubt and no hesitation in saying that this is one of the most preferred, platforms in my law school as far as legal research is concerned, and for which I always appreciate the entire team of EVC SCC.
Yes, sir. Indeed, I really appreciate your answer. In conclusion, what aspect of your work in victimology or criminal justice reform do you consider the most impactful or meaningful? And what legacy do you aspire to leave in the field of Indian jurisprudence?
This is a difficult question. Like if you ask is a film star that which film you find the most, adorable or something like that, it would be difficult. See, it's a long journey, and at different point of time, our priorities were very different. So, like you understand, when you struggle to publish one paper, and if it gets published in the early stage of career, that provide you more satisfaction than what you do maybe at much later in your career when you can do those things much easily. But I must say one thing, all other things I have already explained to you, which are very important high points of my career, whether it is introducing those concepts which I have mentioned, are maybe empirical criminal law or empirical legal research, are so many things which but couple of things always inspire me, and I always maintain. One is I have a lot of hopes from the young generation. I learn a lot from them, and I'm someone who is very well connected with the young student. You will not believe that if a student write me an email from any corner, I try to answer. I may not be answering to many people, but I generally answer this kind of. So I have. So some student has written me an email about one of my article. I was very busy, but I realized that if somebody is reading and raising a lot of question, there is an important thing to answer. So I have sat down and I have replied in detail. So I have a very good connect with young people, and I attend their queries, I respond them, I invite them to NLU Delhi to work as intern. If they write me, I always say yes. And whatever I can do, I try to help them. That is very important for me. I consider this because I'm answerable, I'm committed, and I'm interested to support their journeys in whatever little way I can do. Second thing which I have taken up and which I am drawing a lot of satisfaction is that most of us have been writing in journals and legal books, but one of the contribution that I think that I was able to make some difference. I'm not saying that I have done something great, but I have tried to bring a lot of complex legal issues in most simplified manner in newspaper articles. I try to write in newspaper as much as I can, but those are all very academic and very, issue-based papers. So I have written more than 130 articles in newspapers. Uh, and I keep thinking that what can be the things which I can produce in the public domain in simple language. So simplification of complex legal issues, the reading of people and public is also something which I consider to be one of the most important thing that I can do. And the last thing which I'm currently doing, and which is going to be the path breaking for all of us, that is the application of AI in legal education. So you may be well knowing that I have done two very open and big workshops, online and offline. Anybody can join those workshops where I am demonstrating how different AI tools can make your journey of research and legal education much easier, much effective. And again, I'm thinking to work more and more in these directions.
Yes, sir. Thank you so much for sharing your insights and for this deeply insightful conversation. Today, we have heard a lot compelling synthesis of scholarship and policy, from your foundational work in victimology and wrongful prosecution to the practical steps needed for prison, policing, and juvenile justice reform. Your reflections on the new criminal codes, the operationalization of victim-centric tools such as the victim impact report and the statements, the role of technology in legal education, they really offer a roadmap and challenge to students, practitioners, and policymakers alike. On behalf of the Eastern Book Company and SSC Online, and all the students and practitioners watching this, I express my profound gratitude for your time, your scholarship, and your continuous leadership in shaping a fairer justice system for all. Thank you so much, sir.
Thank you so much. It was such a pleasure talking to both of you. My pleasure. My good wishes to you. Thank you so much.